everyone. How are you?
Hi.
Thanks for coming in on such a beautiful day. I know a lot of you here. I'm Julia Ray. I'm the manager of adult programming here. And I'm just here to very quickly introduce this series. This is the second to last series in what we call the Sandwich Generation, a series designed for folks who may be caregiving or experiencing some challenges related to aging, and create a community conversation here that you're not alone, and there's lots of information to be had right nearby. I want to thank Susan and Paul Doyle of the Oasis Senior Advisors for really curating this, and also our lovely friends at Staying Put in Canaan for partnering with us on this wonderful series. And I hope that you'll join us next month for acute care, right? Navigating hospitals. Very important as well. So without further ado, here is Paul Doyle to introduce the speakers. Thanks, everyone.
Thanks, Julie. I think I see some familiar faces and some new ones, so welcome to the Sandwich Generation. As Julie said, this is the fifth of the six-part monthly series, that we've been doing for the last month. It was very, very cold out when we started, so it's nice to have this weather now. Tonight we're going to talk about all the legal issues that come into play with senior care. Joining us is Ann Fowler-Cruz, who has been a staunch advocate for the elderly and a certified elder law attorney for over 20 years, and is a partner in the law firm of Cohen and Wolf, where she practices elder law, estate planning, and estate administration. The firm has offices in Westport, Denver, and Bridgeport. My immediate right is Michael Lamagna, and Michael is an attorney and client advocate who concentrates in the areas of advanced asset protection planning, trust and estate, elder law, probate and estate litigation, guardianships, healthcare regulatory matters, and special needs law. He is admitted to practice in New York, Connecticut Federal District, and the U.S. Supreme Court. And he is also licensed and practiced as a nursing home administrator in both New York and Connecticut, which brings a very interesting perspective to all this. So thank you both for joining us.
Thank you.
Appreciate you guys coming out tonight. I sort of want to jump in with a lawyer is one thing, but trust and estate lawyer, elder lawyer, there's a difference. Where are the overlaps? What do you guys do under those?
Yeah, well, there certainly is an overlap, and it always is kind of addressing the client's goals and their needs. So estate planning can be anything from a young couple, and they're having a baby and they need a guardianship, to as we age and what are your goals? Maybe they change, right? Your goals change during lifetime. So maybe it's more about end-of-life planning, making sure your voice is heard, preserving assets. So it does blend, it absolutely overlaps.
It does, and by the way, I'm a big fan of Ann Fowler-Cruz. I've known her for a really long time, so it's exciting for me to be here with Ann. What I always say is, I know who my client is in the room. It's usually the person, the senior, that is the client, and a lot of times the family always has a lot of input, but it's the person, it's the client, it's the senior who we're advocating for. And the way that I look at elder law and estate planning is sometimes it diverges and sometimes it converges, and it's looking forward and saying, okay, this is what the next year might look like, this is what the next 5 years might look like, this is what the next 20 years might look like. So it's looking forward and making sure the person's interest is always central.
And for a lot of people, their experience with lawyers would be, I bought my house, I know this guy, or I know a guy from the club, I'm talking to him, he knows this stuff. But what is this? Where is the focus in elder law? Why is that so unique? And what are the biggest concerns that an elder attorney is going to bring to this?
The real estate attorney, first off, throughout our time, law has gotten way more specialized. Where I think when I first started out, people were like, why aren't you doing real estate? Everybody does real estate. I didn't want to do real estate. You can't know everything. And I think one of the big problems that I see is attorneys who don't know or haven't specialized in this area and really concentrating on dabbling in it, because you could do real harm. And you have to be able to understand all the idiosyncrasies, the laws, the regulations, and how they interrelate. I think that you also have to keep up on what's going on all the time, because things change. And there's a lot of rumors and myths that happen. So, I think that from my perspective, there can be a real danger in not going to a professional, just like you wouldn't go to me for personal injury.
Right, and like doctors,
Exactly.
right? We're not generalists, we are specialized. And even between the two of us, we have very different practices, or we have an overlap, but you do a lot of nursing home, you said healthcare advocacy, or he does contested probates, he's a litigator on occasion, right? I don't. So, we have a wheelhouse, we have a specialty, and that's kind of all we do. But we're smart enough to issue spot, and we know that if there's something that comes up, we'll bring in someone else or we'll refer out if it's something that we don't particularly handle. So even amongst elder law attorneys, everyone has kind of their comfort zone or their specialty or where their practice kind of focuses.
Is there a time or reason before, an incident has happened that I want to engage with an elder attorney to sort of get that first introduction so I know how to use that tool now?
It's always nice to get clients before there's a crisis, isn't it?
There.
Yes, we're expertise in crisis planning. That's what we unfortunately do quite a bit of, right? But again, I always ask the client, what's your goal? What's your concern? Why are you here? How can I help you today? That's the first question, and it may just be they want to set up an estate plan, they want to do a will. So I kind of focus their attention on, well, that's kind of death planning, isn't it? What happens if we pass away, which is a very different goal and perspective than if I live a long time, I want to do X, Y, and Z. So I really have to just kind of drill down on the client's goals, questions. Why are you here?
I think that's a great point. We talk a lot about this almost retirement 2.0. So it's easy to say, or it's difficult to say in the beginning, okay, when can I retire? Okay, I make this plan from hit 65, whatever, I'm gonna do this, I'm gonna travel, all this. But we're all living long enough now that it's not a monolith. It's gonna come a time where I'm not globetrotting, I'm not playing as much golf, or I'm not doing other things because that retirement's 30 years. And those are the times where I have to do some planning, that extra piece of planning that I need an elder attorney for.
I think it starts, honestly, when with the power of attorney.
Mm-hmm.
It starts when you're 18 and you do your power of attorney healthcare proxy and living will. I mean, my wife is here, and when our daughter went to college her birthday was in September, and we drove down there and we got her power of attorney healthcare proxy and living will done. Because look, you don't know what's gonna happen, and that's the thing. You don't know when somebody's gonna lose capacity, when someone's gonna get into a car accident, when somebody's gonna get sick. And I'm sure Anna has as well. We've had clients who have early onset Alzheimer's in their 40s and 50s. So it's looking in that crystal ball and saying, we don't know what's going to happen, but we're gonna plan and make sure that if something happens to you later on, we're at least gonna give you the basic tools in your tool belt, which I love, by the way. My daughter's first grade teacher used that term, and I've used it ever since. Where if something does happen to you and capacity is an issue, then we have the tools to move to the next level.
Well said. I did the same thing with my daughter when she turned 18. In my office, signing powers of attorney and healthcare, right? They're an adult. But I also use the expression that life is so fragile, right? We did COVID. We just don't know. Life is fragile. So when is the time to do these documents? People ask that question all the time. Get it in writing. And life changes. Our people in our lives change, so you have to kind of look at your documents every few years and do a reanalysis and see if your goals have changed. The people in these documents may come and go for many reasons, right? So you do have to kind of keep on top of them to just make sure they're still working for you.
So let's talk about the paperwork, okay? So power of attorney, healthcare proxy, and a loaded questions that we have so many clients that come to us and say, child will say, oh, well, I'm the executor on the will, so, yeah.
So I can make those decisions now, right?
Yeah. Okay, so let's clear up the purpose of each of those and sort of strategies and how we look at them.
Yeah. I spend a lot of time educating people on exactly this point. We could spend a long time on it, but I kind of focus people on, again, terminology, and I always kind of boil it down to phases of life. Okay, phase 1 of life, we're okay and taking care of ourselves. Maybe we don't need help. Phase 2 of life, we're alive, but we need help. What documents come into play during that phase, right? Power of attorney and healthcare. And then phase 3 of life, when we pass away, you cannot use a power of attorney if someone's passed away. That's when the will takes effect. Drilling down on each document, we can certainly go from there.
It's important that people understand the positives and negatives to all of documents that they're doing, you know, that, and what the options are. You know, there's a springing power of attorney. I'm very power attorney centric. And that's because of all the things that we see with the power of attorney. And, you know, I call it the primo syndrome. A lot of times people will come in and say, my firstborn son should always be the power of attorney. And I say, well, tell me about for primo. You know, primo's gotten divorced, has a drug addiction, gambles, you know, goes to Vegas. And I'm like, well, that's not good. You know, and exploring the positives and negatives, and exploring also, you know, like what you can put into the documents just to safeguard yourself, like power of attorney as a monitor. You know, so seeing who is in your world, and everyone inevitably says the same thing. I don't have anybody. You know, I don't really have many people, or so on and so forth. And I give them homework, and I'm like, okay, now over the next week, I want you to go in. I want you to see who you call when something happens. What do you do, you know, when you have a question? And they come back and then they say, well, you know, I have this person, I have this person. You know, so it becomes about the power of attorney. And one of the big problems that I see twice so far this week is powers of attorney that are very limited. And now we have to do other things like advanced Medicaid planning. And now we either have to go to court, or we have to get a doctor's opinion, or, you know, so it's, you know, and of course the daughter did it herself. And she limited her gifting ability. She did great job. She did a fantastic job. But she actually limited herself, you know. But you know, you want to safeguard people to make sure that there are things that if something, you know, that the people that they're selecting are going to do their job.
Absolutely. It's not just signing a document, it's really understanding the document and what you want in that document. Because power of attorney, I mean, we've heard the abuse stories, right? We always hear the bad stories, and I like to think most people are good, and most families are good. He's a lip here.
That's because you're practicing this in Connecticut. You're saying that.
That's true. But you know, it's really important that we pick these people, and I go like this, that we hope we can trust and will do the right thing, because we're putting them in charge of making these really important decisions. So you see this power of attorney short form, right, which the real estate attorneys and the generalists will have you sign. And I'm like, okay, it's better than nothing, I guess. But again, as our goals and needs change, as an elder law attorney, we put in or discuss all these abilities. Do we want your power of attorney to have the ability to do long-term care planning, to divest you, to move assets, to support your family and spouse, right? Because powers of attorney are all about you and doing nothing but taking care of you, which is good too, right? But do we want to expand that? So it really is a dialogue and a conversation that takes time.
Let's drill down on that a little bit, on each of them. It's like, what, using the tool analogy again, what is the tool used for, so that I know, let's create the avatar for the person in my life that should be my power of attorney, that should be my healthcare advisor, that should be the executor on my will. If there's a difference, what can they do? And I'll start with, I always find it funny, it's power of attorney. That first word just is so scary to go, I don't trust anybody. I'm not giving power to anybody. Let's,
you know, I sort of talk about it as there's three different kinds, in my opinion. There's a general power of attorney, which you would have for like a real estate closing, and it doesn't outlast your capacity, so it's only really good for a limited period of time. The second is the durable power of attorney, which outlasts your incapacity, which is very, very broad, but starts immediately. So I tell people to think about that. So that means that when the minute that the person signs and accepts the power of attorney or the agency, then they can go into your bank accounts, they can move your house, they can change your deed, they can do all of these really, really scary things. And the third one is called a springing power of attorney, which I do use quite often, depending on the circumstance. And that means that it turns on in two distinct instances. One is when two doctors certify that you don't have enough capacity to make financial decisions. And the second is you can turn it on and sign an affidavit and say, I broke my leg, I really can't get to the bank, so I'm turning it on for this specific purpose. So we sort of explore the different types of powers of attorney. And the person that makes the best power of attorney, the best agent, in my opinion, is the person that is going to be the most responsible and to think and treat money and assets like you do. And if they were in your shoes, they would make the decision that you would want them to make. And one other thing, because Anne was so close to saying what I wanted to say, you know, with people that have special needs children, it's really important that you have, your power of attorney is tailored to you to everybody in their special circumstances, especially people that have special needs kids, because there are times where we have to make transfers to a special needs trust or for other reasons, and people of the generation above us, their children, a lot of times weren't even diagnosed as having special needs. So, there's just a little bit more attention I think that needs to be for those people.
Okay, let's move a little bit into healthcare proxy and what that actually is, and so how we should use it.
Right, so the power of attorney, just to step back for a moment, it really is about the finances. It's the money, the banking, the businesses, the finances, all of that. And we have separated, in Connecticut, we've separated healthcare out of that document, which I think was a great idea, and we've always done it. Two different skill sets, right? So on the healthcare representative, as we call it in Connecticut, healthcare proxy, as we call it in New York, attorney, in fact, for making healthcare decisions, it's got lots of different names. But what is it? It's our agent that's going to make medical decisions for us in the event we are unable. And the neat thing about the Connecticut one is this: if my doctor determines I'm unable to understand and appreciate the nature and consequences of medical decisions, then the doctor toggles onto your agent. I like that, right? There's the kind of the springing to it, right? So it's not the spouse making that decision or the attorney or the kids, it's the doctor. So it's kind of toggles on and toggles off, and typically it is for health, obviously for health care decisions. And that can be anything, I say from stitches, how many stitches, right? To where do we go for what hospital, to what rehab, what procedures, all the way to end of life decisions. So again, that's the healthcare, the kind of the scope of a healthcare document. About the agents that we pick.
Well, so the agents, because it's really important, when you're deciding somebody's healthcare decision making, the agents should be people, in my opinion, that are good under pressure, making decisions. It's not the child that says, I would never pull the plug on you. That doesn't make a good healthcare agent. It's the person that will be calm, cool, and collected, and that you've spoken to and said, this is what I want. When I'm in end of life, when I'm in a terminal situation with no discernible brain function, I wouldn't want to be kept alive by extraordinary measures. I'd want to be, comfortable, and I'd want to go hospice or palliative care, etc. So it's that person. It doesn't have to be a child. It could be that person, that friend, who is going to make healthcare decisions based on what you would have selected if you had capacity. Now, in all these documents, there are successor people, and that's really important. So if the primary person, it's not just when they die, because everyone's always dying in our consultations. What if, they could be sick, they could be part of the sandwich generation, they could have elderly parents themselves they're caring for, and children that they're caring for, and they just can't take this on. So the next person down the line, the successor would then come to be, and then the next person, etc. All too often, and I'm sure you see this too, I see documents where there are no successors. I read my dentist, I read his documents today, no successors at all. And it's very scary because you're just post-pandemic, and I had 53 clients pass away during the pandemic. And I can't even tell you what we went through, but you need to have successors. And it's, once again, those people that make those generalists, attorneys, that don't really do this all the time, they don't have the foresight to know. And if you're a couple, if you're a husband or two spouses, one's going to probably pass away at some point, and then that leaves you to the big C word, conservatorship world, the court world. But you want to avoid.
We'll get into that in a second. You mentioned a friend, you were going through the list of people to consider who were best suited for that. A lot of the times what we see is almost a knee-jerk reaction. I don't want to upset the boat. So all three of my kids are power of attorney. It was just...
Hear that gasp?
I just, it'll take care of itself. It's better that way. Is it better that way, Ann?
Never. I think I can say never, right? Either on the power of attorney or the healthcare. I mean, it's just that, there's one disagreement, they're butting heads. We can't have all three signing every cable check, right? We can't have all three. The doctor saying, okay, are we on board? Okay. It doesn't happen that way. They just want one person to get the answer. My hope, and I tell the family, is pick one person to make the decision, but they'll hopefully, consult with the family, hopefully, right? It takes a team to make some of these decisions, but one point person is what I strongly recommend.
Yeah, same thing, and if you ask, when you're actually using these documents, and it's 10 o'clock at night, and someone's at the hospital, and it's time for a decision to be made, the doctors and the nurses are not going to be calling 3 people. They're just not. And that's when there's infighting, and that's when people start arguing, and no, mom wanted this, no, dad wanted this. It just can't happen because there's no mechanism unless you go to court. And that's one of the purposes of doing the documents with someone like with an elder professional, is that you're trying to avoid going to court and having all these conflicts.
Okay, next piece of legal documents that we run into are trusts. And it's interesting, we sort of got a little bit of a history on this, is revocable trust, irrevocable trust. It almost feels like 20 years ago, revocable trusts, or 30 years ago, were very attractive and were done for a certain purpose, and certain people have those, and now everybody wants an irrevocable trust. So let's talk about what both are, and again, another tool on our belt. So when should we be using them, and when are they not?
Well, I like to use a prop, so I brought one. So I'm going to be very cursory, then I'm going to throw it over to Ann. But basically, I say that a revocable trust is it's a container. The trust is a container. It's a legal contract, and a revocable trust is open like this. So you construct it, you put assets in it, and it's open, so it's available to you. Trustee, it could be yourself, and you're in charge of the assets that are in the trust. Usually, the home, non-retirement assets. These are assets that are completely readily available to you during your lifetime. And in my opinion, revocable trusts have 2 big pluses. The first is during your lifetime. If you become incapacitated during your lifetime, then the next trustee or trustees that you select can manage your assets, can keep you at home, income, etc. So you have full use as well as the successor trustees while you're alive. When you pass away, it does pass to your beneficiaries outside of probate. In Connecticut, we have the 706NT form, so we have a little bit of probate, a tiny bit of probate. In New York, you have none. But in Connecticut, you do have a couple of forms you have to do for estate tax purposes. And so it's the avoidance of probate, and during your lifetime, you have the ability to make decisions. An irrevocable trust looks like the revocable trust. It's very, very similar, except it has a cap. Now, the irrevocable trust, put the asset in, no longer is it available to you. And your trustees are not yourself, and they could be your children or somebody else, but it cannot be you or your spouse. And one of the purposes is to protect assets during your lifetime. In Connecticut, there's basically a 5-year look-back period for Medicaid. And so the assets have to sit here for 5 years, and then they get distributed outside of probate, mini probate, when you pass away. So it's very good for Medicaid planning as well as life insurance trusts, irrevocable life insurance trusts where you put life insurance and you can escape the having your life insurance after 3 years, if it's an existing policy, count towards your gross estate for estate tax purposes.
So I always say, again, back to your goal, right? What is your goal? So clients will say, I want to avoid probate, right? That is a big one for some people. And the revocable trust is a tool to accomplish that goal. Revocable trusts are also a nice kind of management tool, right, while you're alive. And you can also provide for, people want to avoid probate. Well, I say you can avoid probate by putting a beneficiary on the account, by making the account joint. You can avoid probate that way. But sometimes it doesn't quite fit. So, for example, I have a young daughter. I'm not making her my beneficiary on my accounts. She's way too young. She's 24, by the way. It's not that young, but we're not doing anything right now. So I don't leave her as the beneficiary. So I have a trust for her. So that trust is the beneficiary. So again, revocable trusts are a management tool and a way to pass on money in your estate. The irrevocable trusts serve a whole different purpose usually. And again, what is the purpose of it? As you said, protecting assets from long-term care costs. Also, high net worth clients start giving their money away during their lifetime, right? You can give away $18,000 per person per year, that annual exclusion. And sometimes we want to set up a 529, or we want to set up a trust for the children, the grandchildren. Those tend to be irrevocable and start giving the money away while you're alive. But irrevocable, as I said, you can't get it back. It's not yours anymore. You're kind of giving it away.
So let's add, why in the world would I ever do that? And the reason is we're going to get into Medicare and Medicaid. Okay, we're going to dispense with Medicare pretty quickly, but we do want to say there's a difference between Medicare and Medicaid, a big difference. So you should touch on that because the nursing home background. So we've already touched on it, and then let's get into what Medicaid actually is and what it takes. But Medicare and Medicaid, they're not the same thing, right?
No, so Medicare is basically a federal program, and it's the same in every state. It's, like I said, it's federal, and basically it's health insurance for short-term purposes. So for instance, when you're going to a nursing home, you get up to 100 days of rehab. Up to, because everyone goes in, everyone calls me and says, oh, I'm getting 100 days. Well, you're not getting 100 days. But you get up to 100 days. The first 20 days paid 100% by Medicare. If you have traditional Medicare, the other 80 days potentially, there's a copay. So Medicare, you look at, it's federal. It'll pay basically 80% of your hospital visit, 80% of your doctor's visits. Then you have a supplemental. Very important, you have a supplemental program. I know it's expensive, and it's like inflation. I can't tell you, when I first started, supplemental programs were $50, $60. Now they're $400. Yeah, and it's like, don't you shudder when you hear that?
I know.
And I'm like, what? But it's very important they have a supplemental, and so Medicare is really for episodic care. Medicaid is a needs-based program, so it's an income and resource-based program. So it's not, you don't get Medicaid when you're 65 like you do with Medicare. You get Medicaid if you qualify for it. So there's certain income asset and look-back qualifiers. And Medicaid pays for long-term care. Medicare does not pay for home care on a long-term basis. You might get 6 weeks post-hospitalization and post-nursing home stay, but it's going to be, once again, episodic. Whereas Medicaid or Title 19 in Connecticut will pay for long-term care, certain home care programs, nursing home programs.
Okay, so people want to use an irrevocable trust to protect assets to get them closer to the Medicaid requirement or eligibility. Let's talk about what those limits are in the state of Connecticut and what we're actually doing with targeting Medicaid. Because some people, it feels like they get the advice of, oh, you've got to prepare for Medicaid, and just because they've been told to. What does it mean to get to Medicaid? Why am I putting my house and my funds in there and not having access to it? How do I make the decision that that's the right thing to do because I'm doing Medicaid planning?
That's a big question. And it requires a lot of conversations with the client because I kind of back them out a little bit, like again, Medicaid really for older people over 65, it's just going to cover that long-term care, home care, or nursing home, right? But it doesn't generally cover most assisted living facilities, right? It doesn't cover, a lot of things. So we have to think about, is this really a goal? Is this really what we want? Because in order to become eligible for these Medicaid programs, you have to have pretty limited funds. And you won't get your income off of those assets, and how's that going to impact the quality of your life? These are the things we have to think about. Again, pros and cons to every decision we make, and we have to look at both sides of the story here. What are your goals, and look at the consequence to it, right? If you're giving your house away, and there's many ways of giving it away, right? But question number one is, do we want to give it away? What are you losing? Are you getting any benefits? Are you getting VA benefits? You may not be able to reverse mortgaging. You may not be able to, all of these things that you're losing, for what? Perhaps you may need long-term care down the road. And I also say, for whom are you, who's this benefiting? You're giving it away. How does that serve you? Right? How does that serve you? I don't know if it does. It can, but normally it serves the kids and our beneficiaries. Hey, listen, if you say, I worked hard for this money, I don't want it all to be used on my long-term care, and I want to pass it on to my next generation, that's a goal, we can work with that. So it's a conversation for sure.
Yeah, so Mike, what are the conversations when it's a no-brainer, it's appropriate to do Medicaid planning here, as opposed to somebody like, to Ann's point, do you really understand what you're doing?
Well, I actually have the same exact philosophy as Ann, and that's why we get along. Because we really see the world very similar. I always say Medicaid is a may, not a shall. There are attorneys out there, especially in New York, because the laws are very different and much more favorable, actually. And they're almost like puppy mills. Where everyone walks in, goes on Medicaid, and walks out. I mean, it's where they do something at Denny's, and everyone goes on Medicaid and gets a revocable trust. And there's so many downsides and there's upsides. But to answer your question, Paul, someone just has a house and they're gonna live in that house for eternity. And they know it because they inherited it and the basis is really low and they want to stay in this home and they don't have a lot of other assets and it's one of the only ways for them to stay at home. That may be a good candidate to put their house into an irrevocable trust and go on Title 19. Somebody has a crisis and goes into a nursing home, and they have to stay there and there's a community spouse and the community spouse still has to live. Somehow they have to survive. So, you kind of know it when you see it, kind of situation, but even with those people, and it's funny, at 4 o'clock today, I was having the same conversation with a family on Zoom before I got here, and that was even a New York client, and it was, let's think about, mom doesn't have a lot of assets at all, but she does have a condo in Florida, and she just moved here, and she's gonna sell the condo, and she's gonna go on Medicaid, and so on and so forth, and, but I still said, let's think about what you're giving up. So even the no-brainers, you wanna carefully look at.
And you touched on another piece with this, the idea of a community spouse, and you could talk about what a community spouse is, what the limits, how the limits affect them. So if it's clear that so-and-so, one spouse should go on Medicaid because they're going into a skilled nursing for a long time, the community spouse, who are they and what constrictions do we put on them because we convert the other person to Medicaid?
Those are, I think, sometimes the most rewarding cases that we work on because we can really help that healthier spouse. We see it all the time where one spouse goes into the nursing home, right, and the other spouse is in the home or assisted living. The average cost of a nursing home is about $17,000 a month. $17,000 a month. New York, what are they running these days?
20, but the highest is 29.
Wow.
That's the Hebrew home, the Jewish home, in Riverdale.
Wow.
$29,320 per month.
So that's gonna make it, and most people
The
destitute.
pudding's great though.
They have the best jello around.
Right, nobody wants to go to a nursing home, right? But it is necessary in many cases. So again, we don't want to make that community spouse, the healthy spouse, poor and destitute. And that was the rule back decades before my practice, decades ago, right? That Medicaid would only start paying if everybody was destitute. So they finally caught on, let's leave the healthy spouse with some money to survive in the community. So there are protections for that healthy spouse, community spouse as we call it. The home of any value, you can keep the car, tangible property, funeral contracts. There's lots of little things that you can keep. And then the general rule is you can keep half the assets, okay, and they pool everything together. So we have clients, I say we, because I know this happens all the time with you, right? The spouses comes in and like, oh, the money's in my name, so I get to keep it, right? We're like, no. You are one, you're a married unit, so everything is kind of pooled in. You own it, he owns it, she owns it jointly with anybody, it gets put in the pot. And the rule is the healthy spouse can keep half, no more than $154,000. So there's a ceiling, and that half is determined, we won't get into the details, but it's called when you're first institutionalized, right? So you only get to keep half, but no more than $154,000. So a lot of our planning tends to be, how do we protect that overage? And we certainly don't want the healthy spouse to spend more than that. They don't have to. But protecting that overage is what we do a lot of.
Sure. So when you're doing the planning and you're looking, at your 5-year plan, which generally start around 70, unless it's a chronic illness earlier. So you're looking at how what is it that you're going to need after the 5-year period, and then we actually want them to try to be at about $150,000. So the community spouse. It's when you're working. Ann and I both work with financial advisors, and we work with lots of other professionals, Paul and Susan, and just a whole bunch of professionals, so that when we're looking at the forward plan, the goal is to have enough money to spend during the 5-year look back period, have some money potentially gifted, so that there's a little slush fund as well after. But that, sort of a sweet spot would be $154,000, so that the community spouse still has some money to live, and they're not completely destitute. Because they'll come into our offices and they'll say, well, what about me? And I also have to make a plug, so I made a plug for special needs, and I have to make a plug for long-term care insurance, which my wife and I just got. And it is so important for you, for everyone, if you qualify to get long-term care insurance, because what it does is it gives you a head start on the 5-year planning. But it also gives you, sometimes that's all you need is the long-term care insurance. And Medicaid is not a magic bullet, and it's not a universal panacea. It works for some people, but it doesn't work for everybody. So the long-term care insurance gives you a lot more choices.
Yeah.
So, whether it's you, whether it's your children, but we always do a little bit of counseling on long-term care insurance.
If you can afford it and medically qualify for it, I always say, check it out. If you can afford it and qualify, it is worth certainly looking into, because it just gives you options, absolutely.
Yeah, that's an interesting example of using it to get you through the 5-year look back part of the
That's the way to
strategy.
look at it, yeah.
That's a
Defers
great
the
idea.
need.
Now, we've touched about this much on Medicaid, but I think what we have done is it's very complicated, and we go back to the original question of when do I need an elder attorney, is because I gotta tell you, one time we went into Michael's office, he's a whiteboard in his office, and he tried to explain the strategy to us. And it was like being back in calculus. And he had all this stuff drawn, and I'm looking at Susan, you got this, you got this? What do you do? So, I remember. But let's move on to another thing we sort of touched on, which was probate, but I want to get there with conservatorship and what that is. So we've done power of attorney, and that's worked, and that was great, or didn't work. What's conservatorship, and there are different types of it, and when does it come into play, and what does it look like?
So conservatorship takes on 2 flavors. Basically it's person and estate. So conservatorship, the way I describe it is if you don't have power of attorney and healthcare proxies, you haven't really selected the people or have the adequate powers, and you've lost capacity, or that you need more help. There is something called voluntary conservatorship. And I use it quite a lot, where you have that situation where you have someone that wants the core protections, but they're not legally incapacitated. So conservatorship is really a time where the court gets involved, and they select somebody to help you with your personal and financial decision making, because either you haven't done it, or sometimes people have done it and it's inadequate, or sometimes people have done the right documents, but now there's something going on and they wanted to see. So it's a lot of court involvement. And the good thing about it is in Connecticut, it's in probate court, which is a lot friendlier than New York, where it's in the Supreme Court, and it's a lot better. It's a better system in Connecticut. There is, though, a document that I'm sure that we both use, which is called an Advanced Conservatorship Directive, and it's very important. So what that is you can pre-select your conservator. You can say, if I ever need a conservator in the future, for whatever reason, and the courts pick it, I pick this person or these people. Sometimes the courts do not pick the person that you would have picked. They may pick an attorney or someone that doesn't know anything about you. It can be quite difficult, because when you think about people's lives, people are very complicated. You know what your situations are. You know where your bank accounts are. You know how, where your buildings are, where all your things are. But someone just coming in from nowhere doesn't know where anything is or anything about you. So conservatorship can be a positive, but it can also be a negative. With the documents that Ann and I described, the power of attorney, healthcare proxy, and living will, the documents that are the advanced directives during your lifetime, you've selected the people. You've selected the powers. You've said what you wanted. You've spoken to these people. You've spoken to us. Conservatorship sometimes can be a little blind. There is a time and a place for it, especially when there's a lot of contested matters and you have families that just cannot handle the situation. And Adult Protective Services a lot of times gets involved. That's the body, from part of the Department of Social Services that checks up on the elderly when there's a problem or an allegation of abuse and neglect. Conservatorship can be a very large, big deal, expensive, and caustic to the family and to the person. I do a lot of it, which is why I'm a little bit sour on it at times, but it can also be a very positive experience for certain people.
I think in general, though, we want to avoid it.
Absolutely.
The court fees, the attorney fees, and then public information, it's just in the courtroom, accountings. So I think most people we want to try to avoid it.
Well, that's the big spot, right? So we haven't done the planning,
Yeah.
and the next term I want to get into and explore a bit is Because if I haven't laid out the plans of what I want to happen, what is capacity and how is it determined? What does that process look like? When does it come in?
Well, the question of capacity is a question we address every day, we have to make sure our clients understand what they're talking about, what they're doing, make sure they're not being, so we have to canvass our clients all the time. Most of the times, it's not an issue. But, obviously as people age, and I tell people, even with a diagnosis of early dementia, doesn't mean you lack the capacity to sign these documents. But we just have to be careful, whether we get the doctor to sign off that they are capable of signing these documents. But it's an everyday question we ask we deal with.
It's also situational, at times because sometimes somebody will be in the hospital or nursing facility or assisted living or even in a dementia unit. And, and I think that's also when the geriatric care managers, the, physicians, that we partner with, if I have any question, because technically, an attorney can, especially an attorney like Ann and I, can determine capacity at the time of the signing of the document, but whenever there's a question, we'll go the next step and we'll have an independent assessment. So this way we know, and a lot of times it's for estate litigation purposes later, because then someone's going to say, one of the kids will say, well, they did this and that and so on and so forth. It can be difficult, and when it is difficult, we then get other people involved.
How does it come to you? Are you talking to a client and you're noticing something? Is it an adult child or friend or somebody who's involved in their sphere who brought something to your attention? Is it APA, Adult Protective Services or Protective Services for the Elderly here? How does this come up? Or we're now in the hospital and
all the above.
Right, we'll take all the information and wherever it comes from, we'll listen. But typically, I think the capacity to sign a legal document is a legal question, and every document actually has a different standard of capacity. So I think, that we're in a good position to judge that, and if we're concerned, we'll punch to the medical profession for a letter or something like that.
That's interesting. So, in what cases give me an example of how it might vary from?
Right. So I think the will, it has a low threshold of capacity. You just have to know who you are, who your family is, and you have to have some idea of what your assets are. Really a low threshold for signing a will. Whereas a power of attorney, you have to kind of understand each and every item, what banking is, writing checks, you have to have the ability to do all of those items in order to delegate them when you sign. So there's different capacity levels.
We also, with capacity, we've talked about somebody who hasn't set up a plan, who's now showing that they may not have the capacity, and the issue comes up. This is going back into that idea of conservatorship and probate. What does that look like when I just, my dad can't do this right now, or my wife can't do this now? What do we do? I think I need a conservative. I think we need to do this. What is that?
In Connecticut, you're required to get a physician certification. So you get the physician certification, you speak to the doctor, get their opinion, and you try not to really get the opinion of, that can be fraught with issues, because everyone's going to have a different opinion too. I was on the phone with 4 adult daughters just before I got here, and each one of them said something very different. So you go to the doctor and you say, okay, this is, there's been a question of capacity. Do you think this person needs a conservator because they lack capacity, et cetera? And if you get the physician certification, then you have to do a petition to the court to let the court know that you need them to do something, which is have a hearing. An independent, usually attorney, to go and do an assessment of the person to make sure that everyone's telling the truth, and then you'll have a hearing, potentially appoint a conservator of the estate and person if it's warranted. If it's not warranted, they will not. And then, as Ann said, there's a whole world that then opens up with conservatorship as far as doing reports and inventories, and everything is overseen by the court system, which adds expense, time, and if there's a difficult family, a difficult family situation, that's going to be played out in the courts for everyone to see. So it's very much an exposure.
Well, in that, we mentioned the adult kids in that, we mentioned the physician, the lawyers in the middle of this, there's somebody we haven't talked about. And they may have an opinion on it as well, because just because I have no capacity doesn't mean I no longer have a voice.
Well, I'll tell you, it's funny, because I've had clients, I'm sure you have too, that profoundly demented, But the one thing they know is the word conservatorship, and they know that they don't want it. That's all they know. They know they've heard the word and they've heard it's bad, and that's it. They're probably, like, half of you in here will probably be subject to it, and you'll remember this talk. You're like, I heard conservatorship was terrible, you know? So they often do have the opinion that they don't want it, and that's taken, you know.
Well, I mean, and the bottom line is a conservatorship is taking away a person's right. It's big. It's big. So, you know, I don't think anybody wants to have their rights taken away, have their voice taken away. So it's a pretty serious procedure. The court really, you know, supervises it and really wants to make sure that it's done properly because it's taking away their voice.
I know I want to leave plenty of time for some questions with you. I want you to touch briefly as best. We've talked about, and you both have experience with New York and Connecticut. Depending on the state, it's different from state to state.
Yes.
So, and we hear that, you mentioned one thing where Connecticut is better than New York in one phase, but we know that in one phase but in other phases, New York is, how do you compare the two? When are you thinking, hey, you know what, you might want to think about New York, or what are the big differences?
In New York? Maybe probably some more. So I'll jump in with one that always just comes to mind, because we're right on the border, and I'm licensed, we're both licensed in New York and Connecticut, so we have the ability to compare and contrast. And we do it all the time, you know, home care, New York, Connecticut, nursing home, Connecticut or New York. But the big difference that I'm seeing more and more is IRAs, okay? IRAs, 401s. In Connecticut, generally speaking, your IRA is a countable asset. In New York, if you're getting your RMDs in New York, it's not counted as an asset. I mean, that just blows my mind, right? That takes off hundreds of thousands of dollars off the table potentially.
It's a big one, and you know so geography is important because you know not everybody's on the border of New York, but many of us are. So you know, moving somebody from Stamford to Vista or to Rye or Portchester, you know, is a big deal. But you know, you certainly can do it, and I certainly do move people. The other big one is there's no look-back period for community Medicaid, which means that you can move to New York and you could transfer your assets. And you could apply for community Medicaid and get home care, which is another large deal. However, the caveat is March of 2025, they're threatening a 30-month look-back period, or 2.5-year look-back period. Now, they've been threatening this since 2018.
Before pre-COVID, they were.
Yeah, it was pre-COVID. It may happen at this point. I mean, who knows? But part of the problem is that a lot of the city legislatures, parents, community Medicaid are going on community. No, really.
That's
really what is happening.
They're living it.
They're living it. So there's some of that going on, and for many years, you have to move, establish residency. You know, sometimes you lived in that home for many, many years, and you don't want to leave, but you have to move, and then you have to establish residency, which isn't that onerous. The other big difference is for nursing home care is we utilize a promissory, which means that even if you haven't done the crisis planning, you could save approximately half of the value of the assets. So let's say that you have $500,000 and you go into a nursing home, you could potentially save $250,000 of that. So that tends to be a big deal. I have somebody right now whose mom is going to a nursing home, and they've gifted over $84,000 over the years to her. And we're wrapping that $84,000 with the $70,000 she has, doing a promissory note, and she's gonna wind up with $75,000.
Well, we have annuities in Connecticut.
Yeah, annuities,
so it kind
that's
of
more
works.
income-ish.
Well, again, to convert an asset to an income, so it's strategies, but how about spousal refusal?
Well, spousal refusal is, you know, it's
never.
spousal refusal is just for eligibility. That's the thing. You can't escape recovery based on eligibility. So you gotta think about that, because every time you use a Medicaid resource, Medicaid produces a bill, and they used to do, remember the dot matrix?
Yeah.
They used to have the dot matrix machine, and you get this big bill when somebody passed away, when the spouse passed away, you get this like $2 billion bill, and it's this big. You know, so once again, a plug for you know, us elder care professionals. Like, we're gonna consider not only the eligibility part, but we're gonna consider also the estate recovery part, which is because, yeah, it's great to be on Medicaid, but then when you go through probate and you get a bill for, you know, $500,000. So there's different facets.
But just to kind of mention what spousal refusal is, in New York, the healthy spouse can have assets. And if the ill spouse has, under the eligibility amount, the healthy spouse can refuse to contribute those assets to the ill spouse. So you get to keep it, spousal refusal. Again, it's not perfect, they're threatening recovery or recoupment, but it is a tool that we will examine and weigh the pros and cons to. We don't have that in Connecticut.
You get to keep $30,000 of assets in New York
Yeah.
versus the $1,600
That's true.
in Connecticut.
Yeah, so,
So
and
I-
every state is different.
I think this is a perfect time to stop, because as Michael said, you guys have been so restrained, which I know is difficult. I can see the body language, should we really get into this now? But I think that's the message here, okay? We covered a lot of different topics. It's gonna be very different for every person in this room and the ones that you touch. This is why you need these professionals, and this is why you have to recognize that they are, these are locals, these are the people here. You see how accessible they are, you see how easily they handle very difficult questions. You need to talk to them. You can't just wait for it to happen and turn a switch. This is complicated stuff. When you're talking about care that could cost $20,000 a month.
20.
Yeah, but it could cost 20 as well. Do the math. I mean, that whips through a nice estate very, very, very quickly. And so you've got to think about that. So I want to open the floor for any further questions and begin by thanking you.